Good afternoon from Bangkok. A warm welcome to this webinar, a series of webinars being organized in relation to arbitration in Thailand by the Center for International Alternative Dispute Resolution. We have an interesting topic for today's webinar on revisiting the arbitrator's duty, looking at it from a Thailand perspective. This topic envisages both the duty of disclosure and revisiting of the subject, perhaps in light of the judgment in Halliburton and Chubb, a case which no doubt our speakers will cover in more detail. It's worth bearing in mind that the importance of disclosure given the private and confidential nature of arbitration, where discovery is more often limited. Whereas internationally accepted rules and guidelines enumerate common standards and good practice on disclosure and potential conflicts of interest, to what extent are these codes reflected and applicable in the context of Thailand? Also, the question of what comprises of the content of this duty of disclosure. Our speakers today will no doubt address these and other pertinent questions. We have a distinguished panel of speakers today. We have Desmond Hughes, who's senior partner at Hughes Krupika. We have Dr. Roland Amaso, who's senior partner at Vervan and Associates. And we have Nopramat Tamatiradecho, who's counsel at Tilaka and Gibbons. The speakers have been mentioned just in the order in which they will be delivering their presentations. And just in terms of format, we will be having presentations, which will be followed by questions and answers. Please do submit your questions in the comments box. We will take them at the end of the presentations from our panelists. But you can submit these questions during and while their presentations are ongoing. Without further ado, I would like to pass it to Desmond, who will be providing a very broad overview of the subject of disclosure, and also looking at this duty and what this entails in the context of Thailand. Desmond, over to you.
Thank you, Nikki, and hello, everybody. So as Nikki mentioned, I'm a senior partner at Hughes Krupika. I'm also currently the chair of the ICC Thailand ADR and Arbitration Commission and the vice chair of the CIARB Thailand branch. So today I'm going to move fairly quickly through my slides. We're looking at a Thailand perspective of the arbitrator's duty of disclosure, but I am going to juxtapose international law and obviously the recent Halliburton case into that framework. Right. So I will cover why is the arbitrator's duty of disclosure important globally? What does it mean to us? What does it mean to people in the arbitration community? And then very importantly, to the users of arbitration, the parties. I'm going to provide my interpretation of the message from Halliburton and Chubb. Obviously, there are lots of case summaries out there. And everyone has a different focus on elements of that case, but there is a reasonable consensus on the meaning of the decision. Then I'll cover the impact and the Thai perspective, the impact on Thailand. And then finally, I'll talk about something that I think about often and follow closely, and that's arbitrator behavior and how that links to the duty of disclosure. Okay, so at the moment, what global trends are influencing conflicts, disturbing peace, and impacting upon dispute resolution and dispute resolvers? What kind of world are we living in when the duty of disclosure has most recently been analyzed in Halliburton? So we have global trends of resource nationalism. We have 5G nationalism, vaccine nationalism, nationalistic inward attitudes, such as my country first, trade wars, political parties feeding nationalism with nationalistic slogans, and cultural preservation being deviated into nationalism and persecution with an anti-foreign sentiment. that is uniform and is the backdrop, I guess, for the global patterns in which arbitrations are taking place. We have military control, usurping democratic choice of elected leaders, pandemic blame, and migrant exploitation. The reason I'm listing those is really to highlight what parties are seeking in this world that we're living in today. So this is my own summary. Those seeking justice are seeking fairness in a global society where fairness is sometimes a scarce resource on a national and international level. Commercial and investor state parties also seek a forum where independence and impartiality, neutrality, and natural justice can deliver a just outcome. So where does this come from, this high-level view? Well, first of all, I always look at and start with the New York Convention. So Article 5(1)(e) of the New York Convention obviously permits setting aside, and Article 2(b) allows non-recognition of enforcement of an award contrary to public policy. And as we know, Thailand is a signatory to that convention. So whilst I discuss these international agreements or convention, obviously Thailand is very much a part of that. Article 12 of the UNCITRAL model law, that provides the grounds for challenging arbitrators. Article 12(1) requires arbitrator disclosure from appointment and throughout proceedings, and Article 12(2) permits a challenge if circumstances exist that give rise to justifiable doubts as to his impartiality or independence. And it is the justifiable doubt element of that test that has become very important over time and is also relevant, very much relevant in the Halliburton case, and then also in the Thai framework. And then I just want to mention, to make sure we don't forget, Article 18 of the model law relating to equal treatment of the parties. This wouldn't be satisfied if there is a successful challenge under Article 12. So disclosure is the most important element in the requirement of impartiality and independence. If an arbitrator discloses and no objection is made, then the right to challenge is deemed waived. So that's contained in Article 4 and Article 13. And I think Article 4 is so important, it's worth reading out and remembering. A party who knows that any provision of this law from which the parties may derogate or any requirement under the arbitration agreement has not been complied with and yet proceeds the arbitration without stating his objection to such non-compliance without undue delay, or if a time limit is provided, therefore, within such period of time, shall be deemed to have waived his right to object. So this right is time reliant. It's even though there is a duty to disclose conflicts throughout proceedings, actually not making an objection at the time or after disclosure can waive that right, the right to challenge. So independence and impartiality often mentioned together and contained in the same provisions, but actually they're two different concepts. Independence concerns the relationship between an arbitrator and one of the parties, financial or otherwise. And for this, an objective test applies because the arbitrator's state of mind is not an issue. There is an English law case about this. It's in my footnotes. So in that case, it was stated justice must not only be done, but must be seen to be done. Impartiality concerns complete receptivity to the party's arguments. It must not be biased in favor of or prejudiced against a particular party or its case. This test is subjective because it relates directly to the arbitrator's state of mind. So these two concepts, often referred together, I think it's very important to separate them when we're analyzing cases in the framework of a jurisdiction and how it affects disclosure requirements. Now, what are the sources of international law providing guidance on this? Well, everybody should be or is most likely familiar with the International Bar Association guidelines on conflicts of interest. Well, the relevant section is Part 1.3, and that states if facts or circumstances exist that they don't have to exist, may exist in the eyes of the parties or give rise to doubts as to the arbitrator's impartiality or independence. So it's party perception, the eyes of the parties, is critical in this test. The ICC note to parties and arbitral tribunals on the conduct of the arbitration under the ICC rules, which were updated on the 1st of January this year. Part 3A requires a statement of acceptance, availability, impartiality, and independence. Section 26 states a disclosure does not imply the existence of a conflict. This is, of course, very important in relation to spurious challenges designed to disrupt proceedings, and is also very relevant to the arbitrator's mind and consideration on whether or not to disclose, because any lack of confidence in the potential outcome of disclosure should be mitigated by the fact that simply disclosing doesn't imply the existence of a conflict. Section 27 of the note also refers to the eyes of the parties, and also refers to should consider all potentially relevant circumstances, including but not limited to. This wording, all potentially relevant circumstances, is also quite close, but not the same, as the wording in the Thai Arbitration Act, which I'll get onto later. And it's just generally an expansive, liberal interpretation of the test. And the ICC have updated their rules also to cover third-party funder, other arbitral panel members, and expert witness relationships as part of the considerations. So the key differences in the tests and guides in the IBA guidelines, the limitation on disclosure is anything that's occurred within the last 3 years, and under the ICC note, there's no time cap. The IBA has, as I think we're also all familiar, a traffic light system, and the ICC has a wholly subjective test. So already we can see that in these guidelines and the ICC guidance, there is actually a difference to be navigated, and this can be relevant as to which procedures or guidelines the parties may or may not have elected to make binding within the context of their arbitral proceedings. So the challenges also have different tests. UNCITRAL has justifiable doubt, ICC lack of independence or otherwise, SEAC justifiable doubt, and the Hong Kong International Arbitration, any grounds specified in law. So what about Halliburton and Chubb? There are lots of discussions regarding this case, its impact and its meaning. And these are my takeaways. Obviously, it's globally significant. It clarifies how apparent bias is contrasted to actual bias. And this all boils down to the perception of the parties. The case related to the Deepwater Horizon incident, and it was involved claims against Halliburton providing offshore services. It was brought under the Bermuda Foreign Policy governed by New York law. It was London seated, and it was an ad hoc arbitration. The English High Court appointed Kenneth Rockison, QC, and Halliburton opposed that on the grounds he was an English lawyer and the policy was governed by New York law. After he took up the appointment, he accepted 2 appointments in additional arbitrations and didn't disclose these to Halliburton. Halliburton became aware, asked him to resign, and he declined, and very importantly, he declined with reasons. The correct legal test, according to the English Supreme Court, is whether the fair-minded and informed observer, having considered the facts, would conclude there is a real possibility that the tribunal was biased. And interestingly, that hypothetical observer must be assumed as informed. That's the level of knowledge that observer is attributed with. Proving apparent bias and the duty to disclose are separated by time, and failure to disclose overlapping appointments can be apparent bias, but in this case it wasn't. And I think later on in the other presentations and maybe in questions we'll be discussing what perhaps the approach in Thailand would be to multiple appointments. Importantly, Mr. Rockison's fairness, his attitude to the parties, his conduct, the sequence of his subsequent appointments, and then at the time the uncertainty in English law regarding disclosure and a practical method he proposed to resolve at a preliminary stage any of the challenges, they were all mitigating factors in that decision. So multiple arbitral institutions in that case, this case was deemed so important they actually petitioned into the case for there to be a clear standard for the duty of disclosure. In general, whether or not a subjective test applies, it is expected to consider the interests of the parties from their perspective when considering a duty to disclose. Overlapping or multiple appointments may or could create doubt, whether or not justifiable, and the doubt can provoke a challenge, thereby jeopardizing proceedings. And this is, of course, as I'll cover in my conclusion, very important to arbitrators who are busy and are thinking about their next job and considering whether or not multiple appointments may jeopardize a current case. Even though a disclosure could provoke a frivolous challenge, an early disclosure could create an opportunity for a deemed waiver, and further, an early challenge, if rejected, could result in a continuation of proceedings. So the earlier the disclosure, the better. Arbitrators must be very mindful of responding neutrally to challenges, as Mr. Rockison did, and applying neutrality in general. In addition to the knowledge of international law and these non-binding guidelines, which I've mentioned above, i.e. the IBA and the ICC note, which may or may not be incorporated into an arbitration agreement, arbitrators must also look to the seat to establish the parameters of a duty of disclosure. And we'll be talking about the Thai seat. And it must be noted that they may not be qualified in the law of the seat. And generally, a conservative propensity to disclose would be prudent. So, the Thailand perspective. Thailand has a growing regional and international arbitral presence. It has many arbitral institutions operating now. The Arbitration Act has been revised a few times, and Section 19 is the area where the duty to disclose appears, and it mirrors the model code, the justifiable doubts test of England, Hong Kong, Japan, Korea, Malaysia, New Zealand, and Singapore. Now, although it mirrors this test, obviously an important question is, well, how would the courts apply the test, even though the test is phrased in the same way? And it would not be, as per the test of what contravenes public policy, necessarily be the same in each of those countries. I just thought it would be worth mentioning the test is different in a few places. For example, Sweden has a test, circumstances which may diminish confidence in the arbitrator's impartiality. And in the US, there's been some quite controversial debate on the differences between the federal and district interpretations of that test, which include debates over what element of constructive knowledge applies, whether there should be an impression of possible bias test. And I think something also that Roland will discuss in his presentation. In the US, there's been discussion in cases as to whether arbitrators should be held to the same standard of judges, and in certain cases that has apparently been deemed not to be necessary, quite controversially. There are Thai Supreme Court cases relating to international private law arbitration. I'm not going to go through those in detail for reasons of timing, but essentially the private law decisions, the awards were set aside because arbitrators were deemed to have been required to have made disclosures. One case was about a former shareholder being appointed as an arbitrator, and another case where the president of the tribunal used to act as counsel in a related court dispute. That award was set aside. That can be contrasted in Thailand to an administrative, Supreme Administrative Court decision where there was deemed to be no conflict requiring the setting aside of the award involving the appointment of a public prosecutor. And there was a telecommunications company involved in that case. So I think I'll leave it to my colleagues. I think Nopramat might go through that case in a bit more detail to discuss perhaps the differences between private and public law and why that decision was different. So finally, arbitrator behavior. These are the takeaways, I think, from Halliburton and from the fact that this test has resonated globally. So first of all, arbitrators should acknowledge and understand their global and national duties, not just be looking inwardly at their national activities, hence the term international arbitration enshrined in the New York Convention. And they should avoid interpreting provisions narrowly to avoid disclosure due to the risk of challenge and setting aside. So in the erring on the side of caution and making a disclosure to give the parties an opportunity to object, and then waiting for time to elapse so that any opportunity is deemed waived is the most sensible option. An article that I think is really important to reference when thinking about the selection of arbitrators is written by Thomas Schultz on the ethos of arbitration. In that article, the first few pages discusses what the parties expect when selecting an arbitrator, and this is relevant to how an arbitrator should think when they're deciding whether or not to disclose. The parties their perception is paramount based on the Halliburton test. So would they choose an arbitrator thinking that the arbitrator should not disclose a potential conflict, or would they choose an arbitrator thinking that an arbitrator would err on the side of caution and disclose as fully as possible? Notwithstanding the variety of these tests and the variety of legal jurisdictions interpreting independence and impartiality, a uniform principle is perception, and that's perception of the party seeking justice over and above the fact of existence or partiality or bias. What I mean by that is it doesn't matter if partiality or bias exists or not. As I mentioned earlier, arbitrators who have multiple appointments, multiple private interests, such as cross-shareholdings, and multiple relationships, widened recently by the ICC, they become more susceptible to challenges, and that's a fact of life. It doesn't mean that they will limit their opportunity, provided they follow disclosure requirements correctly. Arbitrator conduct is related to a general set of standards on disclosure, and that can extend to other matters on which there are ethical and behavioral standards, such as social media conduct. And a French article that is often cited defines neutrality as taking a certain distance from legal, political, and religious culture. And that can become very important with regards to the perception of the parties of the neutrality of their arbitrator. So historical activity on social media, historical articles, they may need to be disclosed. They may not actually create a challengeable event, but nevertheless, they're important. Arbitrators who spend time outside of arbitration commenting on national proclivities, religious and political matters will, I think, over the short and long term, risk their suitability of appointment and perhaps risk the justice of the parties. Now, something that will also be discussed is the challenge process for arbitrators. And interestingly, in order to try and limit spurious challenges, jurisdictions such as Singapore have adopted a financial approach to deterring this tactic, and they now charge a fee for arbitrator challenges. So I thought that was quite an interesting development. Now, as far as Q&A is concerned, I think we're going to do a Q&A session at the end of all of the panelist presentations, and then my slides, I think they'll be made available later on, and they contain the footnotes and my references in the presentation. Thank you very much for your time.
Thank you, Desmond, for that very comprehensive overview and a good snapshot to the soft law instruments, international soft law instruments, and how this impacts on the assessment of challenges, the subjective approach to arbitrator disclosures, generally encoded, provided in various codes, and also how you neatly sort of distinguished between jurisdictions, the various differences and nuances in terms of language that apply, and how this then in practice much must be developed further. We now move to our next speaker, Dr. Roland. Dr. Roland is going to discuss and chart the developments with respect to disclosure in Thailand, in parallel with the developments of arbitration in Thailand. He surely has a very unique perspective on this subject. Over to you, Dr. Roland.
Hello, everyone. Sawadee Krap from Thailand. Let me make sure that my presentation is uploaded. Let's see. Okay. All right. Can you see my presentation? Hello?
No, we can't.
Oh, okay. Let me try again. Can you see now? Is okay? Is it working?
Yes, but Dr. You may have to open your presentation for it to be before you share screen.
Okay. Share. Okay, let me try one more time. Sorry about that. Does it work? All right. Can you see my presentation now?
Not yet, Dr. Roland. I believe you may have to close it, open up your PowerPoint, and then go through the share screen process once again.
Okay. Let me try again. Stop sharing. Okay. Does it work now? Does it work?
No, I think one of the issues may be that the PowerPoint isn't open before you share the screen. Do you want to try?
My PowerPoint is open. Okay, if
Okay.
it's okay, it doesn't work. You see me, you hear me. I will just dive into the topic right now, and I will share the PowerPoint presentation later. And I think ADR will share with the audience later if you allow me to proceed. You know, I don't want to affect the presentation, the flow of this webinar with the technical issue. So if you can hear me, I will just start my presentation and share with you my view on the duties of disclosure of the arbitrators, focusing on the impartiality and independence of the arbitrators. Okay, so Sawadee then, and I would like to introduce myself. I'm a partner at Vauvant and Associé, which is an international law firm based in Bangkok. I'm the head of international law and international arbitration department. I also direct the digital law, especially now there is a PDPA, Personal Data Protection Act, which is now being passed by the government and will be effective this year. So I'm very happy to be with my distinguished and esteemed colleagues to discuss this very important topic. And I would like to congratulate the Center of International ADR for organizing another very interesting and impactful topic. Thanks for having me. So I have prepared an outline which is quite exhaustive, but I will not get through the detail of the outline since you cannot see it on the screen. This conversation on the duty of disclosure of arbitrators is with no doubt very important, and I would like to thank Desmond for giving a very good overview of the topic, of the subject, by highlighting the cross-cultural dimension of the duty of disclosure, which is very important because what might be required in a jurisdiction may not be the same in another jurisdiction because culture are diverse, because each country has a legacy, a legal legacy that change from a country to another. We have different legal system, the common law system versus the civil law system that might have a totally different approach. And of course, religion, culture, and also can have an impact. So the topic is even more interesting in the particular context of Thailand. So in my presentation, what I would like to do is to focus on one specific aspect of the duty of disclosure, which is the independence and impartiality of the arbitrators and the implication on the integrity of the arbitration system. To begin with, I would like to share with you one quote of a book that has really influenced me. It's a book on leadership. And I imagine, or I think some of you might have seen the book. The title is Book of Leadership and Strategy, Lessons of the Chinese Masters. Let me share with you the quote. When two people get into an argument and each of them think or believe he or she is right from their own standpoint of view, a third party may reasonably decide who is right or wrong, not necessarily because of wisdom or knowledge, but because not being involved in the argument. So this is the end of my quote. And this is the essence of independence and impartiality. That is why disclosure is a core topic of international arbitration, and the importance of the topic cannot be overstated. It is all about trust. It's all about integrity. So because there is no justice without trust, whether it is the judge or the arbitrators, they are required to be independent and impartial. They must not be involved in any way, directly or indirectly, in the dispute or have any interest whatsoever with the parties. In other words, independence and impartiality are the cornerstone of justice that includes arbitration. So, in order to create and maintain trust, disclosure has become the most important element in the justice and arbitration ecosystem. So, to use a terminology that I borrowed from my colleague who are specialized in IT these days, the buzzword is blockchain. So I would like to say that disclosure today is becoming the blockchain of the arbitration institution because its integrity cannot be compromised. Now, let me walk you through the what I call the uniqueness of the arbitration ecosystem in Thailand and the implication for independence and impartiality. As a matter of fact, the context of Thailand is very unique and interesting. How do I put it? Simply presented, in Thailand, the notion of justice has remained a core attribute of the state. This is very important. The notion of justice has remained a core attribute of the state. The development of arbitration as a private justice since 1987 in Thailand has not changed that. And this is very important. And this is what many people miss. So the power to decide who is right or who is wrong remains perceived as a prerogative of the sovereign. From God to the king, from the king to the state, from the states to the state judges. So that sovereignty has been passed from the superpower to the judge and now to the arbitrator. Therefore, the acceptance of arbitration in Thailand, which started in 1954, when Thailand ratified the Geneva Convention on the Execution of Foreign Arbitral Award of 1957. So it has been a long time that Thailand has embraced arbitration. But the uniqueness has remained. So even if Thailand tolerates arbitration, we can observe that the ecosystem of arbitration in Thailand is still very dependent on the state, while in other countries, the evolution points to the autonomy of arbitration with a collaboration of state justice. And one of the best examples is Singapore with the SIAC arbitration, for example. But in Thailand, the two main arbitration institutes that were mentioned by Desmond a while ago, which is the Thai Arbitration Institute and the Thai Arbitration Center, are created under the government decrees or law and administered by state judges appointed by the state to run the centers. It is very symbolic to notice, for example, that the Thai Arbitration Institute has a unique feature of sharing the same building, the same space with the criminal court. That's very symbolic, even if the Thai Arbitration Institute really is dedicated to arbitration. It has nothing to do with the criminal justice, but they share the same building. On the other hand, Thai Arbitration Center is strongly subsidized by the government. Therefore, as far as the obligation of independence and impartiality is concerned, the same mandatory rules which we can find in section 210 and 222 of the Civil Procedure Code of Thailand apply equally to state judges as well as to arbitrators. And this is very interesting. This brings me to the Thai Office of the Judiciary. What is the Thai Office of the Judiciary? So, modern arbitration in Thailand was established under the Arbitration Act of 1987, since 1987. Desmond mentioned the Arbitration Act 2002, but this is an evolution of the first Arbitration Act 1987. So the Thai Arbitration Institute was founded in 1999, which is 3 years later. So it was originally named Arbitration Office under a supervision of the Ministry of Justice. I highlight the word supervision here, supervision of the Ministry of Justice. So the Office of the Judiciary is empowered to discharge the duties of the Court of Justice pursuant to the judicial administration of the court, but it's also supervised arbitration. So Thai Arbitration Institute has the mandate to manage arbitral proceedings in Thailand, and as you can see, Thai Arbitration Institute is under the direct supervision of the state, as I mentioned before. Now let me talk about the Thai Arbitration Center. The Thai Arbitration Center, THAC, is an institution that provides alternative dispute resolution services comprising, of course, arbitration, mediation, conciliation, and cross-border disputes. It was established by an act, by a law, the Arbitration Act Center, 2007. But it's only in 2015 that this center was effectively established to function and to perform and to provide the services. So even though THAC was established as independent, two sections of the law will highlight the support and oversight of the government. Let me share with you those provisions which are very, very important. Section 9.1 stipulates capital and assets used for the center's activity shall comprise of monies received from the government as starting fund and general subsidies by the government as appropriate and necessary. So money received by the government are mentioned in the act. So when we come to independence and impartiality, nothing is more important in arbitration than the independence and impartiality of arbitrators. Why? Because parties hand over their fundamental right to have the dispute heard to one or more individual in hope that they will get it right, that they will have fair justice. As a matter of fact, arbitrators enjoy extensive power to decide on the merit. And apart from some limited circumstances, nothing can be done if they get it wrong. Facts is the fact that the arbitrator will decide the case impartially and independently is very, very important. Now, reaching out to Desmond, I would like to share with you my definition of independence and impartiality in the context of Thailand. Independence refers to the objective and external manifestation of the relationship between the parties, the counsel, and the arbitrators. The key word here is objective and external. The independence is the performance of duties without being under the authority or the control of either party. Independence or the lack of it is factual, so objective, factual, and can be ascertained or proven. But the objectivity of independence is not enough. And that's what Desmond said. The perception of objectivity also matters. So an arbitrator should not only be independent, but should be perceived as independent by the parties. So to make an analogy, if independence and impartiality were assets, were assets, they will fall under different asset categories that we can categorize as tangible and intangible. Independence is a tangible asset. It can be verified, it can be measured. While impartiality is intangible, it's difficult. That's where the difficulties arise, is intangible. So impartiality is when an arbitrator refers to the state of mind. It's subjective, it is abstract, it's difficult to measure. So it can be deducted from the behavior, from the conduct. Now, I saw yesterday a case in Norway where an arbitrator was rolling his eyes during a hearing, rolling the eye during the hearing, and one of the parties felt that the arbitrator was not independent and impartial, and therefore the party requested the arbitrator to be removed just because the arbitrator was rolling his eyes. So this is just to tell you how difficult it is to find a test that measures the independence and, most importantly, the impartiality. But in any case, before accepting the mission, the arbitrator must disclose any fact or situation in relation to the parties in dispute and in relation to the interests, not just the parties, but also to the interest at stake. So the arbitrator of the judge has to appear to be, has to be seen to be, has to be believed to be impartial and independent. So this is very important. So what are the consequences of lack of independence, of impartiality? Of course, Desmond has already covered. There is a legal consequence. The legal consequence is a punishment. It is a sanction. The arbitrator will be removed. And Desmond has already walked us through different legal systems where the procedures of removal of the arbitrators have been spelled out. So what is tricky is the assessment of the test. What kind of test can be used in different laws, different rules and regulations? Some refer to doubts. Some refer to reasonable doubts. Some refer to bias. How do you ascertain doubt? How do you ascertain reasonable doubt? For example, in Thailand, the THAC rules only mention doubt. What about the Thai Arbitration Institute mention reasonable doubt? So what is the most important standard that has to be followed? To summarize on this point, so what is important is to consider the relationship between a party and the arbitrator, the relationship between a party and arbitrator's law firm, the relationship between an arbitrator and the party's counsel, prior appointments, etc., etc. So all those things are very important. Now, let me go to the Thai Arbitration Institute. If you have been appointed as arbitrators for the Thai Arbitration Institute, there is a very interesting procedure. You receive a letter from the Thai Arbitration Institute, and this letter is very specific. Let me read just one sentence for you. With regard to my nomination as arbitrator in the above case, I hereby acknowledge the requirement under the arbitration rules of the Thai Arbitration Institute that as an arbitrator, I discharge my responsibility with independence and impartiality. So this is a statement from the Thai Arbitration Institute, and this is mentioned in the letter. What about the Thai Arbitration Center? There is no such letter, but the rules are very clear. Part 5, duties and disclosure of the arbitrators are very specific. Article 25 mentions that the arbitrator shall perform his or her duty with impartiality and independence. So this is a Thai Arbitration Center rule, very clearly specified. From the rules of Thai Arbitration Center, Thai Arbitration Institute, let's now look at the mandatory provision in the law of Thailand, the Arbitration Act 2002, Section 19 mentioned impartiality, independence of arbitrators. And very importantly, the law provides that the arbitrator should not act as the advocate or the counsel of the parties. And this is very important because some parties that are not familiar with arbitration consider the arbitrator or the arbitrator that they appoint as the advocate that will defend the case in the procedure. As a matter of conclusion, I would like to compare independence and impartiality of judges and arbitrators in a Thai law. What is interesting is that the independence of judges is part of the overall independence of the judiciary under the principle of separation of powers. Judiciary is separated from the executive, and the executive is separated from the legislative power. So the whole principle, the overall principle of independence and impartiality already covers the duties of the judges. As such, judge must be independent not only from the state power, but also from the parties in cases submitted to them. This is very similar to what is requested from the arbitrators. In the Arbitration Act of 1987, there is a section 14, paragraph 3, that provides for the opportunity to challenge the arbitrators using the same ground set in the Civil Code of Procedure to challenge the judge. So judge and arbitrators are under the same standard, the same mandatory rules of independence and impartiality. What is also to be noted is that this provision is not replicated in the Arbitration Act of 2002, but I believe that it still can be used as a reference. So, because a judge can be challenged on different grounds, the same as the arbitrator can be, I believe that in Thailand, judges and arbitrators are really under the same obligation of disclosure if they are related to the parties or they are related to the case or they have any interest. How to conclude? What I will see based on my experience is that Thailand already has a solid legal framework to deal with arbitrator duty of disclosure. Whether it is in the law, whether it is in the Arbitration Institute rules, there is already a very good, solid legal framework. So the obligation of independence and impartiality is embedded in the Thailand justice tradition and extends to arbitration. So to understand the essence of arbitration in Thailand, one must also understand how Thailand understands justice, whether by the state judge or as an arbitrator. Is a reform, is a change necessary? My answer is probably not, because all necessary tools are already in place. What may be needed is some adjustments to cope with international standard, international cases such as IBA rules, UNCITRAL practices, disclosure requirement from different jurisdictions that can guide the evolution of arbitration in Thailand, and of course, the practice of arbitrators in Thailand. So this is what I would like to share with you from my perspective in the context of Thailand, how independence and impartiality is addressed. Thank you for your attention. I will share my presentation with Priyanka later, and she can share with the audience. Thank you very much. Kokunkap.
Thank you, Roland, for taking us through the mapping of the duty of disclosure in Thailand, all the way from the devolved powers to how arbitrators and judges have almost the same disclosure duties under Thai law and within the framework of the Thai arbitral institutions. Now we move on swiftly to Nopramat. who will be covering the practical aspects of disclosure for Thai-seated arbitrations and before Thai arbitral institutes, taking a more ex-ante approach from a review of cases and examples that she's come across. Over to you, Nopal.
Okay, thank you, Nikki. And thank you, my colleagues, to share the interesting point of view. So I'm a litigation counsel with Tiliki and Gibbons. I handle the domestic and international arbitration as well as the litigation cases. So actually, I think that my topic that I like to discuss today is actually share with my experience and the case study for some case that I have the handle. So I like to share the screen with you. So now you see the screen, right? Okay. Actually, I have 4 topics to cover, but I think that maybe I save my time and to discuss only the important topics here. That because other topic that about how the important for the arbitrator disclosure is actually discussed by our colleagues already. So I think that. In terms of the arbitrator duty of disclosure, it is versus the challenge tactic. Why I say that? I like to share with you that as the counsel, when I acting at the claimant counsel, sometimes we appoint nominate the arbitrators, and most of the time that it is quite difficult that we can get the agreement from the opposing counsel to nominate or agree on the arbitrators. So usually the opposing counsel raise the issue of the conflict of interest, objecting our nominated arbitrators. That is why I say that it is the tactic that counsel use in order to maybe delay the case, to prevent the good arbitrator to make the decision, to make the good adjudication on the case. So that is something that we have to aware that it is not only the duty of the arbitrator that the arbitrators themselves have to disclose. On the other hand, we have to aware that the tactics that the counsel may use in order to challenge the arbitrators by using the ground for the conflict of interest. If the arbitrator not be frank or open about their background concerning the related case that they handled in the past. So if you can see about the duty of the disclosure of the arbitrator, you can see that even exit convention, it says something that the convention put a threshold for the arbitrator uphold challenge only if arbitrator exhibit manifest lack of the qualities. And manifest lack of the quality here in many exit precedent case is saying something like appears of bias standard. It means that you have to prove that the arbitrator have the appearance of the bias. So come back to Thailand. For Thailand Arbitration Act, my friends refer to Section 19 that put or impose the duty of the arbitrator that they have to review the information that could disclose the information that could cause or lead to justifiable doubts. So this is something that the arbitrators or the nominated arbitrator have to aware this duty in order to prevent what? To prevent the challenge, to prevent that the the future award that be challenged in Thai court. Same thing. This is for THAC rules. They also say that for the person appointed as the arbitrator shall disclose the facts that may rise doubts over his or her impartiality and independence. So move from the domestic law, domestic act, to the institutional rules. So we can see that institutional rules also impose very clear duty. However, the sections seem to be very clear, but when in the real situation, it's quite difficult to interpret the section or the article. Why I say that? I have some cases that I experienced. This is quite unique for Thailand. That according to the dispute over the concession agreement between a private party and the state enterprise, right? So this is according to the concession agreement concerning sometimes is infrastructure operation, sometimes is the telecommunication concession. So this state enterprise, it means that the government shares have the majority share more than 50% in those state enterprise. What is the problem for this kind of cases? Why I use this case to talk to you? Because in Thailand, when the state enterprise, they have the arbitration disputes, especially the domestic arbitration. The state enterprise may choose either to engage the counsel from the Office of the Attorney General, or they can choose to engage the lawyer, private lawyer. So, but mostly in my experience, the state enterprise, they choose to engage the attorney from the Office of Attorney General. As you, according to Thai law, what is the law of the Office of the Attorney General? They have two laws. First law in criminal case, sometimes we call Attorney General as the public prosecutor who prosecute the criminal case under the Penal Code of Thailand. And secondly, they have in the civil case, the Attorney General acting as the counsel to the state enterprise or to the government regarding to the contracts, commercial contracts, or the contract related to the public infrastructure, including concession agreement. That's why the state enterprise in Thailand usually engage the attorney from the Office of Attorney General. So as you can hear from my friends that already refer to some of the Supreme Court precedent in Thailand, saying that the Thai court rules that would be the that will be the conflict of interest, and if the counsel become in the case become even in the related case, not the same case, and become nominated as the arbitrator, so that is the considered as the conflict of interest. However, in those cases, it's very interesting that why this arbitrator not review the cases that they involve. There's so many background issues from that. But I like to go to the challenge when when the claimant counsel challenge the respondent counsel as from the Office of Attorney General. First, why? Because we think that this nominated or the arbitrator from the Office of Attorney General, they are not independent. They may be influenced by whom? Because the Office of Attorney General, as you can see, they have the bureaucratic system. They are the public servants. So they have the supervisor, have so many boss in each level. Whether or not this arbitrator have to consult the case with their boss at the Office of Attorney General or not, this is the big question. When the claimant counsel challenge the respondent counsel, challenge the appointed arbitrator by the respondent counsel. After this kind of cases, the Office of Attorney General have to issue the letter as the guideline for the Attorney General who have to work as the arbitrator in the case dispute over the concession of the state enterprise. That letter set the line that this Attorney General who is the arbitrator in the case, they should not share the information with the related supervisor. This is to uphold the independence and the impartiality of the arbitrator. So that is something that it makes the public aware that if the Attorney General become the arbitrator, there will be the impartiality and independence. Whether or not it's true, it's something that the claimant counsel have to find the evidence to prove. And secondly, why we say the Attorney General who acting the arbitrator would not be the independent and not impartial, because according to the Attorney General Act, already imposed the duty to the Attorney General as the public servant that they have to protect the best interest of national or the public interest. So you can see that it is kind of the two things that this arbitrator have to protect. First, they have to protect the impartiality and the independence. And secondly, can they also protect or act like the good Attorney General to protect the national interest? It seems to be difficult, right? Very difficult. And thirdly, Attorney General's salary paid by the Ministry of Finance, because they are the public servant. And the Ministry of Finance in Thailand, they are the majority shareholders of the state enterprise. Yet, as you can see, and the link here is that according to Thai laws, the board of directors of most of the state enterprise require that the chief of the Office of Attorney General have to be one of the directors in those state enterprise. So, before I go to the English case, so as you can see from the Thailand experience, that should the Attorney General disclose their previous case either in the law of the counsel and as well as in the law of the arbitrators, Yet I think they should do. However, I have one previous case, also the same, these concession agreements, that it appears that the Attorney General who act as the respondent nominated arbitrator from the Office of Attorney General, she acted previously as the counsel for this state enterprise during the time of review and drafting concession agreement. You see, this Attorney General acting since before the dispute even alive, and then when the dispute alive, she be nominated as the arbitrator for the state enterprise. So for this thing, it seems to be clear that there was some conflict of interest here, and yet there is challenge. There's challenge in the court. However, in this case, Thai court dismissed our challenge for the state and for this non-disclosure. So this is quite disappointing issue. Okay, so I think that for the disclosure duty concerning the law of the Attorney General, there should be something that Thai court may have to consider more, because in the view of Thai court, in several Supreme Court decision, it seems that the court believes that the Attorney General who acting as the arbitrator, they should be independent and impartial. So it is also difficult as the counsel to examine some of the tests that the court put and consider in those cases. Why? Because Thailand considered as the civil law country, that when the court apply the law to the fact, usually they not put so many details in that judgment. That is something also cause some the difficulty when you going to challenge for the arbitrators on the duty of the disclosure. And another difficulty is that for the IBA guidelines on the conflict of interest, considering as the soft law, it is something that not well recognized in Thai court. So this is something I think that it's not everything is the fault of any party or even the Thai court. Why? I think that in my experience, we try as the counsel, we try to introduce the IBA guidelines on the conflict of interest to the court as the factual issues when we challenge the arbitrator. So that is something that we could do as the counsel, right? However, it would take some time, because right now I think that some counsel already proceed or introduce this IBA guideline as the soft law, as the factual issues to Thai court already. But we may have to wait for a few years time in the next few years to wait until the court recognize these issues and to apply or even adopt the concept of the justifiable doubt or any details or guidelines in IBA on conflict of interest. I still think that is something as a council we can do, because apart from this, concerning the amendment of the law or anything else, I think that could take longer time to introduce the guidelines to Thai court or the arbitration community in Thailand. So that is my point. And I like to conclude my presentation with the latest English case, the Halliburton versus Chubb. Whether or not this case could be used or could be introduced to Thai court when we try to argue to the opposing party that okay, we want to appoint these arbitrators. However, the case that we handle that consider the multiple claims and multiple cases altogether. You know, in Thailand, if we have like or maybe the same 3 cases of the Halliburton case, and we win the first case in the first arbitration case, and we want to also appoint or nominate the same arbitrator to the second case. It's related overlapping cases. Same thing. My experience, whether or not, the question is whether or not this can be challenged yet, and should the arbitrator review disclose the information to our party that he have handled this case before. I think something the opposing party would know about this case, because it's the small industry. Everyone know each other, and in Thailand, I think that only no more than 10 arbitrators that handle this kind of international arbitration. So, yet the opposing lawyer object the arbitrator to be in the same related case. However, the case not go so far like the Halliburton case. Why? Because usually the arbitrators in Thailand who been challenged by this kind of claim, they would offer to resign. They not insist in the case further, and it stop there. Then you have to find a new arbitrator to adjudicate the case. So that is something maybe different, and I think that the thing that would be very interesting that if we could take some point that the English court puts really interesting details in the case. For example, informed observer. It doesn't mean that the person outside the case may think that this is something have the conflict of interest, and consider that if you are the arbitrator in this case and you should not be, there is no rule or no guideline to saying that you cannot be the arbitrator in the multiple claims, right? As long as you can prove that these arbitrators impartial and independent. So I agree with the Halliburton's the court rulings, and I hope that one day we could introduce the same thing to Thai court. It is the job of the counsel who have to introduce the factual issue, either the foreign judgment or the soft law like IBA rules guidelines to the court. You cannot wait that the court will take this kind of soft law to the Thai court judgment. That is incorrect. It's not possible. You have to do it as the counsel. So that is my point. And anything else that I like to talk on this issue. So that's it for my presentation. And thank you.
Thank you, Nopramad, for that very comprehensive discussion on how Thai courts approach the issue of potential conflicts and disclosure requirements, as well as some of the concerns in practice in Thailand as to the appointment of the Attorney General and perhaps what Thai counsel, like all of us, could do to further strengthen and prepare challenges which also take into account internationally accepted standards like the IBA guidelines, in order to then be able to create a more uniform standards given the international nature of arbitration. We have roughly 5 minutes left, and I had sort of promised my colleagues that I will hopefully be able to end the session on time in light of the Chinese New Year that many of my friends and others that are listening to this webinar may be looking forward to celebrate later on today. We have one question that we have received from our participants, which is there any, are there any unanimous guidelines for arbitrators? I assume guidelines in terms of disclosing potential conflicts of interest. Maybe someone wants to just quickly address that, or perhaps address the question, should there be guidelines that are more widely accepted, or should be more widely acceptable by various jurisdictions?
Nikki, if I can take this question, and then I will pass it to my other colleagues. I think it's very difficult because we have to consider the seat of the arbitration, because the seat will determine the consequence of the behavior of the arbitrator in terms of challenge of the award or not. As we can see, different jurisdictions have the different rules. So the only solution is, for example, the IBA rules on conflicts of interest of the arbitration. But again, this is a soft law that cannot be enforced as a law of any jurisdiction. And that is exactly what Nopramad is saying, because you cannot ask the Supreme Court to enforce the IBA rules. And this makes things complicated. Maybe Desmond would like it, to take it from there.
Okay, so I agree with that. But basically, it does depend on the jurisdiction, because the courts supervising and looking into this do not have to accept soft law as the final test. An interesting solution that the commercial parties can try, and this is not absolutely steadfast, but it can certainly strengthen the duties in the guidelines. They can expressly incorporate the IBA guidelines as a term of the agreement between themselves. Now, this I've seen done before, because in a challenge and a response to a challenge, I've seen responses that state the IBA guidelines are guidelines only. Guidelines don't mean I absolutely have to follow the guidelines. But obviously, if a contract states that the guidelines are deemed binding by the parties, then the question then becomes, does the law of that jurisdiction recognize that the parties are allowed to make the IBA guidelines a binding contract between themselves under contract law? So that is a solution, but the answer to the question, as I agree with Roland, there aren't unanimous guidelines. There's soft law, and that is not uniformly applied throughout the globe.
Yes, I think that okay. Somebody said that IBA guidelines on the conflict of interest try to balance between the common laws and civil law world, and that's why they try to introduce these guidelines as a soft law to the international arbitration. However, I think all of you may heard about the PLAC guidelines that introduced, because some of the civil law lawyers think that the IBA guidelines seem to be unfavorable or oriented to the common law arbitration. So now you have like two guidelines: IBA's guideline for the common law, PLAC's guideline for the civil law. Yet anyone can introduce several kinds of guidelines. ICC's rules start in Paris toward the civil law world. Now the other institution in the common law also have the rules that yet civil law lawyer may not agree that is favorable to the civil law lawyers. So same thing. So I think that for this soft law, it's clear to be the flexible, not to be a concrete rules. So, and flexible is the key thing for the arbitration. I think that the solution is how to create the rules or the soft law to become the rules. Arbitration gives people the autonomy to choose. As Desmond said, you may put the guidelines in the clause of contract, or you may choose the PLAC's rules, PLAC's guideline into your contracts. But the important thing that whether or not the party foresee the negative or positive effects of those guidelines when the dispute arrive. So that I think that would be the keys before we put anything or we make any option, something that at the council. Sometimes we have to fix something that never been in the contracts before, right? Because the corporate and commercial lawyer draft so many kind of contracts, but they never go to the arbitration or the dispute. But we are the fixer, so we have to find a solution, whether or not how to introduce these rules to the court or this soft law to the courts. I think that the way that I would solve this kind of problem is you have to know when you draft the contract what kind of guidelines that you may use, or what kind of the rules of the institutional arbitration that unfavorable to you. So I think that that's something more than you have the single concrete guidelines. Thank you.
Okay.
Well, thank you for those responses. And I think also importantly, I mean, one of the ways is where courts sort of take into account these IBA guidelines as perhaps being non-binding, but sort of a reflection of internationally accepted standards. Similar to as the UK courts have recently sort of considered the IBA guidelines to be. And the other important element of this is that parties do agree and adopt rules, arbitral rules of procedure. And in those rules, disclosure obligations as well as an assessment of challenges relating to conflicts of interest are prescribed therein, and those obviously apply to the parties and to the arbitrators that are appointed under those rules, and those will obviously have an effect on sort of how sort of the guidelines as to what the arbitrator must comply with when they are being appointed under particular institutional rules. With that, sort of we sum up today's webinar. We've obviously looked at the wide international framework with the IBA guidelines. We have also looked at the difficulty with looking at impartiality from a subjective perspective, and how this would have to be perceived by a court, by a Thai court, and also how difficult it is if we draw an analogy between counsel appearing from one law firm and the arbitrator appointed from the same law firm, and drawing that analogy to the situation with appointing an attorney general, where also they serve as counsel in the same case. So lots of very, very interesting aspects that have been raised. We are now roughly 4 minutes, and we don't see any additional questions. So we'd just like to thank all our panelists for their time and for their very interesting insights into this topic. Also, a big thank you to the Center for International Alternative Dispute Resolution. I understand that the center will circulate the presentations, and the panelists have agreed to send out the presentations to whoever would like to have a copy of these. Wish all our Chinese viewers a happy New Year. And with that, we draw today's webinar to a close, and hopefully see you in the next webinar. Thank you.
Thank you, Nikki. Thank you very much. Thank you.